Hello friends, welcome to Prashant IAS. So friends, first of all I'm sorry I was unable to upload lectures from last 3 days because my laptop was not working and I tried every method but it was not working. So finally I took my laptop to the technician, but he was saying that sir, I need at least 5 days to repair it. But friends, I was worried about you all. So I finally purchased a new laptop because I don't want to compromise on your future. So I purchased a new laptop, and friends, now I have my new laptop with me. So from today onwards I will upload the lectures daily. Okay? So friends, in the last class we have discussed till article 19 clause 1 subclause B. And from this class, we will continue our discussion with Article 19, Clause 1, Subclause C. So friends, Article 19, Clause 1, Subclause C says that it guarantees a fundamental right to form association of any kind. So what is Article 19, Clause 1, Subclause C? It guarantees a fundamental right to form association of any kind. Now what is association? So association means a type of registered group. So what is an association? Association means a type of registered group. So for example, if you are a citizen of India, then you have the fundamental right to form any kind of association. Okay, it includes right to form political association and trade union. So Article 19 Clause 1 Subclause C also gives you the right to form political association and trade union. Now what is a political association? So friends, I will give you one example to make you understand this concept very clearly. Suppose friends, if you are not happy with the ideology of any political party, suppose if you don't believe in Hindu ideology, if you don't believe in umbrella ideology, if you don't believe in communist ideology, so if you are not happy with the ideology of any political party in the country, then you have the right to form your own political party. Okay, so suppose if you are not happy with the ideology, with the work of any political party, and you don't want to join any political party, and you want to oppose the other political parties, you want to form your own government, then you have the right to make your own political party. Okay, so the citizens of India have the right to form any kind of political association, which includes political party also. But you have to comply with the rules and regulations of Election Commission of India. Okay, so you have to follow the rules and regulations given by Election Commission of India, but you can form a political party also. Similarly, if you are a citizen of India, then you have the right to form a trade union. Now what is a trade union? So suppose if you are a trader, okay, and suppose there are 1,000 traders in your area and you are one of them. Okay, you are doing some business or trade. Now you can form a trade association, you can form a trade union by uniting all these traders. Okay, so now you all are a part of one trade union. So what is a trade union? So it is a kind of registered group in which the group members are traders of one area. Okay, so now you have formed a trade union. Similarly friends, right to form cooperative societies was added by 97th Amendment Act 2011. Now what does it mean? So friends, originally right to form cooperative society was not the part of our constitution, means it was not guaranteed under Article 19 Clause 1 Subclause C. But in year 2011, Parliament amended the constitution for 97th time. And by 97th Constitutional Amendment Act 2011, right to form cooperative societies was added in Article 19 Clause 1 Subclause C. So now we also have the right to form cooperative societies. Now friends, what are these cooperative societies? So this is a totally separate topic and I will take a separate class to explain this topic. Okay, this is a dedicated topic in our syllabus. So we will talk about this in a dedicated class. Now friends, right to form trade union doesn't mean a fundamental right to strike. Therefore, right to strike may be a legal right but not a fundamental right. Now what does it mean? So suppose I give you the example that you are a trader and in your city there are 1000 traders. So all these 1000 traders including you form a trade union. Okay, so now you are a member of a trade union and there are total 1000 members in your trade union. Now friends, why you form trade union? Actually you form trade union so that your voice can also be represented. Now suppose if you have certain demands from the government, okay, if you have certain demands from the government regarding certain facilities or anything else, and if you want to talk to government, okay, then you can definitely put your demands through your union in front of government. But friends, even if government is not fulfilling your demands, then also you do not have the right to do strike as a fundamental right. Suppose if you have certain demands, okay, suppose if you have certain demands from the government and government is not fulfilling your demands, then you can do strike against the government. You have this right, but this is not a fundamental right. This is just a ordinary legal right. This is not a fundamental right. Means this right is provided to you by the parliament of the country, but this is not provided to as the fundamental right. Now what is the significance of this? So its significance is that suppose if you have certain demands from the government and government is not fulfilling your demand and you want to do strike. Okay, so if you want to do strike, then you have to take permission from the DM or SP of your district. Okay, and suppose police is not allowing you to do strike. Police is saying that your strike can disturb law and order, sir, and we cannot allow you to do strike. Then as this is not a fundamental right, as right to strike is not a fundamental right, so you cannot directly approach Supreme Court against the police that, sir, police is not allowing us to do strike against the government. As this is a ordinary legal right, so you can go in subordinate court, lower court, but you cannot directly go to Supreme Court. Okay, so friends, try to understand this very clearly that right to form trade union is a fundamental right. So government cannot stop you from making any trade union, and if government or anyone else is stopping you from making any trade union, then you can directly file a case against government or anyone in the Supreme Court of India. But right to strike is not a fundamental right. It can be an ordinary legal right. So if police is not allowing you to do strike against the government or to do strike against anyone, then you cannot file a case against the police in the Supreme Court of India. You can file a case against them in the ordinary court, but you cannot file a case against them in the Supreme Court. So this is the significance of this statement, that right to strike is not a fundamental right. It can be an ordinary legal right. Now friends, Supreme Court has declared that Bandh is illegal. Okay, so you all must have listened about Bandh. So on Tuesday, the farmers unions called for Bharat Bandh. Okay, so Supreme Court has declared that Bandh is illegal. So what happened, friends, on Tuesday? I think on 8th of December, that many farmers unions called for Bharat Bandh. Why? Because they were actually protesting against the government for many farm acts. Okay, so the union government has bought certain farm acts and farmers are not happy with these acts. So farmers are protesting up against these farm acts. Okay, so in their protest against these farm acts, many farmer unions called for Bharat Bandh on 8th of December, means on Tuesday. So friends, now according to the Supreme Court of India, Bandh is totally illegal. Why Bandh is illegal? Because first of all, it involves an element of force. Okay, now what is this element of force? So suppose if there are some shopkeepers or some business owners and they do not want to close their shops, they don't want to be the part of your Bharat Bandh, then what happens that people who are actually supporting this Bandh, they force them and they forcibly close all these shops. Okay, and they forcibly close all the things. So it involves an element of force. It is not an voluntary thing. It is an forceful thing. So according to Supreme Court, this is illegal. And the second reason is that it brings a complete shutdown of business and disturbs public life. Now what does it mean? So I will give you one example to explain this statement. So friends, suppose there is a person and the name of that person is Rahul. Now what happened that Rahul has got heart attack. Okay, so Rahul got heart attack and he needs hospital and doctor. Okay, so he immediately needs hospital and he immediately needs doctor. But due to Band, entire transportation system was closed. Even hospitals were closed. Everything was closed. So due to Bharat Bandh, he did not get hospital and doctor, and due to this he died. So actually, the people who are supporting this Bharat Bandh, he killed him. They killed Rahul. Okay, so they actually violated right to life. Okay, so they violated Article 21 given to Rahul, because Rahul is also a citizen of India. So Rahul also has right to life, Article 21. So these people who are actually supporting the Bandh, they actually violated the Article 21 given to Rahul. Why? Because actually they killed Rahul, because they shut down they shut down all the transportation system and hospitals and all the things. That's why Rahul died. So according to the Supreme Court of India, if there is Bandh, then Bandh actually completely shut down all the business and it disturbs the public life. For example, according to the report of The Hindu, the Bharat Bandh declared on Tuesday, it mostly affected the public life in the states of Punjab, Odisha, Telangana, Andhra Pradesh. So these were the states in which the general public life was affected mostly. Okay, so Bandh is illegal. Okay, so now friends, Bandh is illegal according to the Supreme Court of India because it brings a complete shutdown of business and disturbs public life, because everything is closed. And if a person needs something emergency service, for example, the person who was dying out of heart attack, he needed hospital, he needed doctor, but due to Bandh, he did not get doctor and hospital and he died. So this is a illegal thing. Okay, now friends, as this is in news, so the question can be asked in prelims as well as mains from Article 19 Clause 1 Subclause C. So I request you all to study this article in detail, to study this article, and actually I am teaching you this article. So it is your duty to revise this article, because it can be asked in prelims as well as mains. Why? Because this is in news. So this is very important for us. Now friends, what is Article 33? And why I am teaching you Article 33, I will tell you. So Parliament has the power to put restrictions on any fundamental right, including right to form association available to security forces in the interest of nation. Now what does it mean? So it means that the Parliament of our country has the power that by passing a law, Parliament can put restriction on any fundamental right. Okay, so Parliament has the power to put restriction on any fundamental right. So friends, Parliament has the power to make law, and by making a law, Parliament can put restriction on any fundamental right which is provided to the member of security forces, and including right to form political association. Okay, so what power Parliament has? So Parliament has the power to declare by law that these are the restrictions which should be imposed when the members of security forces will enjoy the fundamental right. Now what does it mean? So in the simple words, we can say that Parliament has the power to put restriction on any fundamental right, including right to form political association which is available to security forces. So Parliament has the power to put restriction on any fundamental right given to security forces. Here I am not talking about the ordinary citizens of India. Here I am not talking about the civilians. Here I am talking about the member of security forces. So the word security forces should be underlined. Okay, so Parliament has the power to put restriction on any fundamental right which is provided to security forces, including right to form political association. Now friends, Parliament has used this power, and Parliament passed many laws and denying right to form political associations to security forces. Now what does it mean? It means that Parliament passed the law, and by passing the law, Parliament declared that security forces in India do not have the right to form political association. So in India, security forces do not have the right to form political association. For example, Army cannot form political association. Member of ITBP, Indian Tibet Border Police, they cannot form political association. Similarly, the members of Border Security Force, BSF, they cannot form political association. Now why this is so? This is because friends, the members of security forces has arms in their hand. They have weapons. They are very powerful. They have AK-47, missiles, rocket launcher, and actually the entire security of India is on their soldiers. Okay, on their shoulders. So friends, if they will get the right to form political association, then this can be a threat for the security and sovereignty of India. Okay, so if the members of security forces will get the right to form political association, then they can do anything. Then they can bargain with the government, and it is not allowed. Why? Because this can be threat for the security of India, for the sovereignty of India. That's why Parliament passed the laws and Parliament denied right to form political association to the members of security forces. Now friends, according to the Supreme Court of India, civil servants associated with the security forces also do not enjoy right to form political association. Okay, so all the civil servants who are associated with the security forces, okay, these civil servants also do not enjoy right to form political association. Why? Because actually these civil servants have their big influence on the members of security forces. These civil servants have big influence on security forces. So if they will get right to form political association, then they can also cause threat to the security and sovereignty of India. Okay, so they also do not enjoy right to form political association. Now friends, let's move further. So then comes Article 19, Clause 1, Subclause D. So what is Article 19, Clause 1, Subclause D? So it guarantees right to move freely throughout the India. Okay, so Article 19, Clause 1, Subclause D guarantees to all the citizens. Definitely, as Article 19 is guaranteed only to the citizens of India, so this article means Article 19, Clause 1, Subclause D is also guaranteed only to Indian citizens. So it guarantees to all the citizens right to move freely throughout the India. Now what does it mean? So it means that as we all are the citizens of India, so we have the right to go anywhere in India. For example, if you live in Tamil Nadu, then also you have the right to go to Bihar. You can go to Haryana, you can go to Telangana, you can go to Punjab, you can go to Gujarat, you can go anywhere. Okay, so government and any other person do not have the right to stop you from moving anywhere in the territory of India. So as we all are the citizens of India, so we have the right to move freely throughout the India, and government cannot stop us from doing so. No person can stop us from doing so. And if anyone stops us, then we can directly file a case against him in the Supreme Court of India. So this is our fundamental right. So if you want to go to Gujarat, you can go. If you want to go to Delhi, you can go. If you want to visit India Gate, you can visit. Okay, so this is your fundamental right. Now friends, this fundamental right have certain restrictions. So it can be restricted on certain grounds. For example, on the grounds of security of India, on the grounds of public order, on the ground of interest of scheduled tribes. Now what are all these grounds? I will give you one example so that you can understand this very clearly. Now friends, for example, you are not allowed to go in the Chandipuram complex in Odisha. Okay, so whether you are a citizen of India or not, you are not allowed at all to go in Chandipuram complex in Odisha. Why? Because actually it is a rocket launching station, and if you will go there, then you can cause threat to the security of India, and definitely it is also not the interest of your security, as well as it is not in the interest of the security of India. That's why you are not allowed to go there. Similarly friends, I will tell you one story. So what happened? So there is a tribe known as Jarawas tribe which lives in the Andaman Island. So Jarawa is a very famous tribe of Andaman Island. So what happened once, that tourists who were going to visit Andaman Island, actually they were going to the place of Jarawa tribe, and the tourists were offering them food, and in the exchange of food, tourists were requesting them to perform dance. Now friends, actually they maintained a very primitive form of life, so their attire is very different from our attire. Okay, so actually they live almost nude. They do not wear much clothes. They live almost nude. So so what tourists did? Tourists requested them to dance, and they offered them food in the exchange of their dance. So the people of tribal community, they started dancing because they do not know all these things happening in our society. And what tourists did? Tourists actually recorded their dance and put their nude dance on the YouTube. Now friends, according to the Supreme Court of India, this is against the dignity of the people of Jarawa tribe, because Article 21 guarantees them also, actually, as they are also the part of our country. So Article 21 guarantees to them right to dignified life. And actually, if you are luring them out of food and you are putting their nude videos on YouTube, so this is harmful to their dignity. So actually you are violating their right to dignified life. Moreover friends, actually, as we are living in a industrial world, so if you have many bacterial disease, for example, if you got typhoid, then your doctor will give you antibiotics, and after taking antibiotics you will be cured. But friends, as we are habitual of taking antibiotics, so our body is not that natural. So what these tourists did, so these tourists actually came into contact with the people of Jarawa tribe, and they transferred harmful bacteria from their body to the bodies of Jarawa's tribe. Okay, and due to this, many people of Jarawa tribe caught many bacterial diseases and they actually died. Why? Because they do not have doctors and antibiotics to treat them. So actually, tourists were actually violating their right to life. First of all, they were violating their dignified life, and secondly, they were indirectly killing them by giving them bacterias. So friends, finally the Supreme Court of India ordered that the road which connects the Andaman tourist place to the residents of Jarawa's tribe should be banned, should be made inaccessible to the tourists. Okay, and now you are not allowed to go to the road which connects the tourist place to the Jarawa's tribe, and definitely you are not allowed to visit the place of Jarawa tribe because it is not good for their interest. Actually, you are a threat for their life. Similarly, friends, there is a concept of inner line permit. Now, what is inner line permit? So, suppose if you want to go to the state of Arunachal Pradesh, Mizoram, Nagaland, and Manipur, then you need a document called as inner line permit. So, what is inner line permit or ILP? So, ILP is a document which you need if you want to visit the state of Arunachal Pradesh, Mizoram, Nagaland, and Manipur. And without inner line permit, the government and police will not allow you to enter inside the territory of Arunachal Pradesh, Mizoram, Nagaland, and Manipur. Now friends, Manipur is a recent entry in the list. Earlier we needed inner line permit only in the states of Arunachal, Mizoram, and Nagaland. But Manipur is a recent entry, and I think that from 1st January 2020, the inner line permit was implemented in Manipur also. So before 1st of January 2020, we didn't need inner line permit to visit the state of Manipur. But after and from 1st of January 2020, we need inner line permit to visit the state of Manipur. Okay. Now friends, the question arises that actually why this permit is needed. We all are the citizens of India, so why this kind of laws are there? Why inner line permit is needed to visit the states of Arunachal, Mizoram, Nagaland, and Manipur? Okay, so what is inner line permit? So if there is a citizen of India, who lives in any other state, okay, suppose if you lives in Madhya Pradesh and if you want to go to Arunachal Pradesh for some work, then you need inner line permit to get entry into the Arunachal Pradesh. So it is a kind of document which will give you entry in that state. Now friends, question arises that actually why the inner line permit is needed. So I will give you answer. So first of all, the security reasons. Why? Because these states share border with foreign countries. Okay, so it is a possibility that you may be a supporter of some other country. You are some intruder. You want to you want to disturb public order in that state. You want to provoke the people of the state against the government. Okay, so you may be a supporter of any other state. You may be a terrorist. Okay, so in the interest of India, in the interest of security of these states, the inner line permit is needed. Means government has the account of all the people, of all the outsiders who are visiting their state. So first of all, inner line permit is very essential for the security reasons. The second reason is that the economy of these states is very big. Okay, now what you can do, actually, if there is no need of inner line permit, then you can easily establish a industry there. And if you will establish a industry there, you can actually kill the employment of the people living there. Okay, so by establishing an industry, the big industrialists in India can kill the employment of the local residents of these states, and the economy of these states is very, very big. So that's why inner line permit is needed, so that the big industrialists cannot destroy the employment of these states, employment of the local residents of these states. Moreover, friends, these all states are ecologically sensitive areas, and these are the all reasons why inner line permit is needed to get entry into these states. Now friends, inner line permit is in news. Why? Because some leaders from Meghalaya are demanding that inner line permit should also be implemented for the state of Meghalaya. Okay, so some leaders from Meghalaya are demanding that inner line permit should be implemented for the state of Meghalaya also. Okay, and they are having their talks with the central government. So this is in news. So definitely there are chances that question can be asked from Article 19 Clause 1 Subclause D, as well as inner line permit in your UPSC prelims 2021 as well as UPSC mains 2021. So please prepare this topic in much detail. I will teach you this topic and you have to revise this again and again, because there are very strong chances that question can be asked from this topic, because this is in news. So friends, let's move further. So then comes Article 19 Clause 1 Subclause E. So what is Article 19 Clause 1 Subclause E? So it guarantees to every citizen right to freedom of residence and settlement. Now what does it mean? Suppose you are a resident, you are a domicile of Tamil Nadu. Then also nobody can stop you from buying property, from settling in state of Madhya Pradesh, in state of Bihar, in state of Uttar Pradesh. Okay, so what is Article 19 Clause 1 Subclause E? So it gives a fundamental right to every citizen of India, that any citizen of India can reside in any place. Any citizen of India can buy property anywhere. You can make your house anywhere. You can do trade anywhere. You can establish your industry anywhere. Okay, so you have the right to buy property. You have the right to reside anywhere in the territory of India. Now friends, earlier what was the practice? That we were not allowed to buy property and to reside in the state of Jammu and Kashmir. But after the Jammu and Kashmir bifurcation bill, and as now it is a union territory, okay, so now we have the right to buy property there. Okay, but you cannot buy agricultural land. So recently it is also in news. So you cannot buy agricultural land, this is a condition, but you can buy other lands. You can establish industry there also. Okay, so now friends, as the central government has announced that now any citizen of India can buy property in Jammu and Kashmir, any citizen of India can establish his industry in the state, in the union territory. Okay, so many local leaders from Jammu and Kashmir, they are actually protesting it. Okay, so they are saying that the central government is trying to encroach on the property of Jammu and Kashmir. They are saying that this decision of central government is not good. Okay, now you are very intelligent to decide whether this decision of government is good or not. I can only say that every decision of government is always not bad. Some decisions are actually very, very good. Now you know that whether this decision is good or not. Okay, so now for academic point of view, for our exam point of view, or we only need to know that central government has announced that now any citizen of India can buy property in Jammu and Kashmir, and definitely, but you are not allowed to buy agricultural land. Okay, and in order to buy any property, you need the consent of the local of the person who is holding the property. Okay, so friends, then comes Article 19 Clause 1 Subclause F. So actually it was right to property, But by 44th Constitutional Amendment Act 1978, it was removed from the list of fundamental rights. Okay, so now right to property is no more a fundamental right. So by 44th Constitutional Amendment Act 1978, the Parliament of India removed right to property from the list of fundamental rights. And now what is the current status? So currently it is a constitutional right under Article 300 capital A. So right to property is not a fundamental right. Right to property is a simple constitutional right, and right to property is given under Article 300 capital A. Now friends, let's move further. So friends, then comes Article 19 clause 1 subclause G. So what is Article 19 clause 1 subclause G? So it guarantees a right to vocation, that is a profession or a trade of one's choice. Now what does it mean? So it means that if you are a citizen of India, then you can do any profession, you can do any business. Suppose if you want to do business, you can do it. Suppose if you want to open a multi-brand retailing showroom, you can open it. Suppose if you want to open a industry, you can open it. Similarly, if you want to become a doctor, you can become a doctor. If you want to become a carpenter, you can become a carpenter. Means if you are a citizen of India, then you can do any profession, you can do any occupation, okay, you can do any trade. Now friends, state can impose some restrictions or qualifications in some professions in public interest. Okay, so it means that government has the power to impose some restrictions or some qualifications on some jobs. Now you will say, sir, this is the violation of Article 19 clause 1 subclause G. So actually it is not violation, it is in the interest of public. So let's see how. Now suppose there is a person and the name of that person is Pappu. Okay, now the name of that person is Pappu. Okay, now Pappu wants to become a doctor. Okay, so Pappu wants to become a doctor, but Pappu is only 8th pass. He is only 8th class pass. Okay, and he failed in 9th class many times. Suppose he failed in 9th class for 10 times and he is unable to pass class 9th. Now if he is saying that I want to become doctor, and if he becomes doctor, then you can imagine what he can do with his patients. He can actually kill his patients. So actually this is the violation of the right to life of other persons. And definitely right to life is the most important fundamental right. You cannot sacrifice someone's life for someone's other's freedom. Okay, so right to life is very important fundamental right. So now state has put certain restrictions, certain qualifications, that if you want to become a doctor, then you should at least have some graduation degree. If you are MBBS, okay, so if you have passed MBBS degree, then only you can become doctor. Okay, so if you want to become an allopathic doctor, then you have to do MBBS. If you want to become an Ayurvedic doctor, then you have to do BAMS. Okay, so there are certain qualifications that if you have these qualifications, then only you can do this job. If you do not have these qualifications, then you cannot do this job, because if you will do this job without these particular qualifications, then this can be threatening to the life of other people. So in the interest of public, in the public interest, government can put certain qualifications or restrictions on some jobs, not on all jobs, on some jobs. Similarly, friends, government has the power to declare some business, some trade as government-owned trade. Now, friends, state can even overtake a business or trade partially or completely, provided it is in public interest. Now, what does it mean? Suppose there is a businessman and the name of that businessman is Pappu. Okay, so now suppose Pappu has Pappu is an industrialist. Okay, and Pappu has a industry. Let's suppose Pappu has a sugar making industry. Okay, and if government thinks that it is in public interest, that now the ownership of this industry should be snatched from the hands of Pappu and the ownership of industry should be transferred to the government of India, then government can do so. Whether Pappu is agree or not, it does not matter. Government can snatch the ownership of the company from Pappu. And actually it also happened in the past. So when it happened, so actually in 1969 and 1980, nationalization of banks was done. Okay, so nationalization of many banks was done in 1969 and 1980. So what is nationalization? So nationalization means earlier these banks were privately owned. Means their owners were private individuals. But in the interest of public, what government did? Government snatched the ownership of these banks from these individuals and government owned these banks. For example, friends, earlier SBI was a private bank, but after the nationalization of the bank, it became government owned bank. Similarly, Punjab National Bank was also a private bank, but after the nationalization of banks, it became a government owned bank or a nationalized bank. So we will discuss about the nationalization of banks in much detail in the economy class. Okay, so here we have to understand that government has the power to overtake any business or trade partially or completely in the interest of public. So friends, now let's move further. So friends, then comes Article 20. Now friends, I want to tell you one thing, that Article 19 is very very important for exam. So please do prepare Article 19 in much detail, because in news, repeatedly in news, Article 19 is coming. Okay, so Article 19 is coming in news repeatedly. Many provisions of Article 19 are covered in news repeatedly. So there are very strong chances that question can be asked from any provision of Article 19 in prelims 2021. Now friends, let's study Article 20. So what is Article 20? So Article 20 says that protection in respect of conviction of offences. Now what does it mean? So let's study Article 20 in detail. So what is conviction of offences? So it means to prove in the court of law that a person has actually committed any crime. So actually let's study all the clauses of Article 20 one by one in detail, then you will understand that what is the meaning of this statement. So friends, first of all, we will study about Article 20 clause 1. So what is Article 20 clause 1? So Article 20 clause 1 prohibits the state from enacting ex post facto criminal legislation. Okay, so what does it mean? So it means that state is prohibited from enacting ex post facto criminal legislation. Means criminal laws cannot be given retrospective effect. So what does it mean? So it means that criminal laws cannot be given retrospective effect. Now friends, this is little bit technical, so I will give you one very beautiful example to make you understand this concept. So suppose friends, there is a person and the name of that person is Tukaram. Okay, so name of that person is Tukaram. Now suppose in 2010 robbery was not a crime. So I am just giving an example. Actually robbery is a crime, but suppose, okay, robbery is a crime, but for understanding, for the matter of understanding, just imagine that in 2010 robbery was not a crime. Okay, so in 2010 what Tukaram did? So Tukaram actually looted a jewelry shop and he looted the jewelry worth rupees 20 lakh. Now friends, what happened? That the owner of the jewelry shop filed a case against Tukaram in the court of law. But actually, as in 2010, robbery was not a crime. Okay, so court said that Tukaram is not a criminal and court freed him. Okay, court left him free. What happened, friends? In 2012, the parliament of the country came with a new law, and according to that law, robbery became a crime. And parliament said that if any person will commit robbery, if any person will loot any other person, then he will be given a punishment of suppose 10 years. Okay, so in 2012 what happened? In 2012 parliament came up with a new law, and according to that law, if a person will commit robbery, then he will be given a punishment of at least 10 years. Now friends, when that jeweler listened about this news that now robbery is a crime, so he again filed a case against Tukaram in the court of law. So again Tukaram was summoned by the court of law. Okay, but friends, this time also court left him free. Why? This time also court said that he is not a criminal. Why? Because according to Article 20 clause 1, no criminal law can be given retrospective effect. Means court cannot punish Tukaram in 2012. Okay, so court cannot punish him Tukaram under a law which is made in 2012 for a crime which Tukaram did in 2010. Now what does it mean? So it means that actually Tukaram committed the robbery in 2010, but the law came in 2012. Okay, so before the making of the law, Tukaram committed the crime. So now, as law was made after the commencement of the crime, so now court cannot give punishment to the Tukaram. Okay, so this is the meaning of retrospective effect. Means court do not have the power to give punishment under a law which is made in 2012 to a criminal who committed some crime in 2010. Okay. Now, as Tukaram has committed the robbery in 2010, but in 2010 robbery was not a crime. In 2012, Parliament came up with a law and Parliament declared that now robbery is a crime. But when Tukaram committed the robbery, at that point of time, robbery was not a crime. So now court do not have the power to give punishment to Tukaram. Why? Because Tukaram committed the robbery at that point of time when robbery was not a crime. Okay, so what is the meaning of retrospective effect? What is the meaning that criminal laws cannot be given retrospective effect? So it means that suppose if a law is enforced on 30th of January 2012, okay, suppose if a law is enforced on 30th of January 2012, then the person who have committed the crime before 30th of January 2012, suppose there is a person who has committed the crime on 29th of January 2012, then that person can also not be punished under that law. Means then court cannot give punishment to all those criminals who have committed the crime before the commencement of the law. Okay, but court can punish all the criminals who have committed the crime after making of the law. Okay, so suppose if the law was made on 30th of January 2012, then no person can be punished under this law who have committed the crime before 30th of January. Okay, but all the persons who will commit crime after 30th of January 2012, they all will be given punishment under the law. So this is the meaning of retrospective effect. So retrospective effect means enacting a law and giving it effect in back time. Okay, so retrospective effect means if a law is made in 2012 and it can be implemented for the crimes of, for the acts of 2010, 2011, 2010, 2011, 2001, 1998, 1990. So it is retrospective effect, but it is actually prohibited. Means state cannot give retrospective effect to the criminal laws. Means if a law is made in 2012, if a law is enforced on 30th of January 2012, then the persons who will commit crime on or after 30th of January 2012, they will get punishment under the law. But the persons who have committed the crime before 30th of January 2012, they will not get punishment under that law. Okay, now friends, the example of Tukaram and robbery and jeweler, it was all imaginary, because actually according to the IPC of India, robbery is a very big crime. Okay, and IPC was made much before the independence of India. So it was just an imaginary example in order to make you understand. And I hope that you all must have got the meaning of Article 20 Clause 1. Okay, so Article 20 Clause 1 says that criminal laws cannot be given retrospective effect. State is prohibited from enacting ex post facto criminal legislation. Okay, and this article only gives this protection for criminal legislation. This protection is not given to civil legislation. Okay, so this type of protection is only given to criminal laws. So friends, there is a very famous example for this article. So the juvenile in the Nirbhaya case, he got only 3 years of imprisonment. Why? Because when he committed the crime, at that point of time, the new law was not made. So when Parliament made the new law, at that point of time, crime was already committed. Okay, so when that person committed the crime, at that point of time, so when Nirbhaya case happened, at that point of time, the new law was not in existence. And actually Parliament made the new law after the happening of the Nirbhaya case. So as the crime happened before the commencement of the law, so that juvenile only got 3 years of imprisonment. Okay. Now friends, according to Article 20 Clause 1, punishment can be decreased for backdate offences, but it cannot be increased. So again, I will give you one example to make you this thing more clear. So suppose friends, if there is a person and that person has committed a crime. Okay, so if that person has committed a crime in 2010. Okay, and in 2010 there was a law which declares that this act is a crime. Okay, so suppose let's take the example of robbery again. Okay, so suppose in 2010 robbery was a crime, but according to the law, for robbery the maximum punishment can be 5 years. Okay, so suppose in 2010 also robbery was a crime and the maximum punishment for robbery was only 5 years. Now friends, again that person Tukaram looted a jeweler and he looted that jeweler and he looted the jewelry worth of rupees 11 lakh, worth rupees 20 lakh. Okay. Now friends, suppose what happened in 2014. So this time let's take the example of 2014. So what happened in 2014, government amended that law and government declared that now if anyone will do robbery, if anyone will loot someone else, then for the commencement of robbery the punishment is 15 years. Okay, so government increased the punishment, means earlier the punishment for the commencement of robbery was 5 years, but now government increased the punishment to the imprisonment of 15 years. So friends, now according to article 20 clause 1, if Tukaram has committed robbery in 2010 and the law was amended in 2014, then Tukaram will be tried in court according to the law of 2010. Means the law of 2014 will not apply on Tukaram. So Tukaram will be given imprisonment of only 5 years. Now suppose another condition. Okay, now suppose another condition. Now suppose that in 2010 the punishment for robbery was 5 years. But in 2014, government amended the law and government said that now the punishment is only 2.5 years. The punishment for the commencement of robbery is only 2.5 years. So if punishment is decreased, then the law can be applied for backdate offences. So now suppose as Tukaram has committed the robbery in 2010 and in 2014 government has amended the law and government has said that earlier the punishment for robbery was 10 years, but now the punishment for robbery is 2.5 years. So now if court will give punishment to Tukaram, then now court has the power to give only imprisonment of 2.5 years to Tukaram. Okay, so what does it mean? So it means that punishment can be decreased for backdate offences, but it cannot be increased. Okay, so punishment can be decreased for backdate offences, but it cannot be increased. Now friends, let's move further. So then comes article 20 clause 2. So what is article 20 clause 2? So article 20 clause 2 says double jeopardy is not allowed. Now what is the meaning of double jeopardy? So it means that state is prohibited from practicing double jeopardy. Means no person shall be punished more than once in a court of law for committing a single offence. So if any person has committed one offence, then court can punish him only one time. So no person can be punished more than once in a court of law for committing a single offence. Now what does it mean? So again I will give you one example so that you can understand it more clearly. Now suppose friends, if there is a person named as Rahul and Rahul has committed robbery. Okay, so suppose Rahul has committed robbery in 2010. And in 2010, according to the law of 2010, it is just an example. It is not the real condition. It is just an example to explain you. So suppose in 2010, the punishment for the robbery was 5 years. Okay. So in 2010, court said that Rahul will be given the imprisonment of 5 years. So Rahul was imprisoned and Rahul was released from jail in 2015. Now court cannot give further punishment to Rahul for the single offence. Now court cannot say that Rahul will be imprisoned for 2 more years. Court cannot say that Rahul will be imprisoned for 3 more years. Or court cannot say that now Rahul has to pay 5 lakh rupees to the government. Court cannot say this. So what does it mean? It means that court can punish you only once for a single offence. If you have committed one crime, then court can give you punishment once. Court cannot punish you 2 times for a single crime. Okay, for example, court punished Rahul in 2010 and Rahul was imprisoned from 2010 to 2015. But now court cannot increase the the duration of the imprisonment of Rahul, or after the release of Rahul, court cannot say that now Rahul has to be kept in the jail for 2 more years. Okay, so it means that the court of law do not have the power to punish you 2 times for one offense. Okay, so if you have committed a single offense, then you can be given punishment only single time. You can only be punished one time. Okay, court cannot punish you 2 times for one offense. So it is a simple principle, one offense and one punishment. Court cannot punish you twice for a single offense. So this was the meaning of Article 20 Clause 2. Now friends, suppose if there is a civil servant and that civil servant has the charges of corruption and his charges are proved, or if that civil servant has committed murder or any other crime, okay, and it is proved. So first of all, the department will remove him. Okay, so it is also like a punishment. So first of all, the department will remove him from the job, and secondly, the court will give him punishment. Court will give some sentence to him. Court will say that he will be imprisoned for 5 years, 10 years, or he will be given capital punishment. So friends, here it is not the violation of Article 20 Clause 2. It is not double jeopardy. It is not double punishment. Why? Because some persons may say that, sir, first of all, department is punishing him, then court is punishing him. So this is not double jeopardy. Why? Because department is not a court of law. According to the language of Article 20 Clause 2, it gives us protection against court of law. Means court of law cannot punish you 2 times for a single offense. But department is not a court of law. So if department has removed you and then court of law has given you some punishment, then it is not the violation of Article 20 Clause 2. Now friends, let's move further. Then comes Article 20 Clause 3. So what Article 20 Clause 3 says? So according to Article 20 Clause 3, no person accused of any offense shall be compelled to be a witness against himself. Now what does it mean? So it means that suppose if you have committed any crime, then police or the government cannot force you to say anything which they can use in court of law to prove your crime. Okay, so what does it mean? So it means that police or the government cannot force you to say anything, cannot force you to do anything which can be used as an evidence, against you in order to prove your crime in the court of law. Okay, so it means that state shall not compel you to be a witness against yourself. So no person accused of any offense shall be compelled to be a witness against himself. Okay. So friends, what happened in Rehan murder case, that the bus conductor, I don't know what is the correct word, conductor, cleaner, okay. So you search that word on your own, okay. So I have listened conductor, so I am saying conductor, okay. So the bus conductor means the ticket checker of the bus, okay. So the bus conductor was forced by police to accept the crime, okay. So what happened in Rehan murder case, that bus conductor was forced by police to accept the crime, and actually it was the violation of Article 20 Clause 3. Why? Because actually police do not have the power to force the conductor to give any evidence against himself. Okay, so what Article 20 Clause 3 says? So it says that government or the police cannot force you, cannot compel you to say anything, to do anything which can be used as an evidence against you in the court of law, which can be used as an evidence in proving your crime. Okay, so what happened in Rehan murder case? That conductor was forced by police to accept the crime, but it was actually illegal. It was against the spirit of Article 20 Clause 3. Now friends, please do search this, that what is the correct word, conductor or cleaner or ticket checker. I don't know what is the correct word, but he is the person who checks ticket in the bus, and actually in my region he is commonly known as conductor. So I have mentioned the word conductor. I don't know what is the proper word for conductor. It is cleaner or it is ticket checker. Okay, it can be anything. So you do it on your own. Now friends, it is not an absolute right. Okay, so Article 20 Clause 3 is not an absolute right. Now what does it mean? It means that state can impose certain restrictions on it. There are certain restrictions on it. So I will give you one example. So what happened in famous stamp scam case? So there was a stamp scam case, and what happened in that stamp scam case, that Abdul Karim Telgi. So who was Abdul Karim Telgi? He was the main convicted person. So Abdul Karim Telgi was subjected to narco test. And what happens in narco test? That in narco test, Abdul Karim Telgi was given truth serum. And after having truth serum, he will only say truth. He cannot say lie. Okay, so police will interrogate him and he will say truth. He will not say lie. But friends, court said that this type of interrogation, means the interrogation which was based on narco text, it will not be used as an evidence to give punishment to the convicted person. Means the statements given by Abdul Karim Telgi during his interrogation in the narco test will not be used against him in giving him punishment. Then why narco test was conducted? It was conducted so that police can get information, and based on the information, police can collect evidences. Okay, so police will use the information obtained from Abdul Karim Telgi, okay, and police will find more evidences. Police will find more information, and based on the evidences found by the police, court can punish Abdul Karim Telgi. Okay, so there are certain exceptions also. Means in some extraordinary condition, court can order to do something which is outside the scope of Article 20 Clause 3. So friends, now let's move further. So then comes Article 21 capital A. So friends, Article 21 capital A was originally not the part of Indian Constitution. It was introduced in Constitution by 86th Constitutional Amendment Act 2002. Okay, so in 2002, government means Parliament amended the Constitution for 86th time, and through 86th Constitutional Amendment Act 2002, Parliament amended the Constitution and added Article 21 capital A in the Constitution of India. So what Article 21 capital A says? So it says that state shall provide free and compulsory education to every child of the age group 6 to 14. Now what does it mean? It means that it is the duty of the government to provide free education to all the children who lies in the age group of 6 to 14. Suppose if there is a child in your home, whose age is 7 years of age, okay, whose age is 7, then it is the duty of the government to provide free education to that child. Okay, so it is the duty of the government to provide free education to all the children of the country whose age is between 6 to 14. Now friends, free education is enforceable on the state. Means it is the duty of the government to provide free education. For example, in government schools, in government owned schools, the education is free of cost. Okay, but the compulsory education is enforceable on the parents. Why? Because government cannot compel the children, and government cannot forcibly bring children to school. So it is the duty of the parents to send their children to school. And this led to the addition of fundamental duty under Article 51 capital A clause K. So what is Article 51 capital A clause K? So it is that it is the duty of the parents to send their children to the school. So it is the fundamental duty of the parents. So definitely we will study about Article 51 capital A clause K in much detail when we will study about fundamental duties. For the time being, you just understand that it is the duty of the parents to send compulsorily their children to the school. Now friends, then comes Article 21, and Article 21 is a very big article, so I think we should not start it today. So we will start Article 21 in the next class. So friends, if you have enjoyed the lecture, then please like the video, comment on the video, subscribe to my channel, press the bell icon, and share this channel to all the people you know who are preparing for UPSC. Friends, you can download the notes from the link given in description, as well as you can directly download the notes from my blog prashant-ias.blogspot.com. Till then, take care of yourself. Thank you.